Hello everybody and welcome to an introduction to European Union law. In this lesson what we're going to do is take a very brief introduction to the study of the European Union by taking an examination of some of the descriptive realities of the European Union. So talking about what the European Union actually is, talking about the way in which the European Union is regulated, the kind of member states that exist within the European Union, the way in which the European Union has developed over time, and then outlining the scope of this series of lessons, talking about the things that we're going to be covering in this series of lessons. It is the first in a brand new series that we have on the law of the European Union. I've put a little exclamation point in the end of it there to highlight my excitement with doing EU law again. And this is, like I said, the first lesson where we're going to take an introduction to the subject as well as outlining the scope of this series of lessons. So ultimately, the first question that we can ask, and that you probably should ask if you are somebody who is studying European Union law and has never had any interaction or any relationship with the European Union at all, is, well, what actually is the European Union? And this would be a confusing question to ask if you are somebody who lives in Europe, pretty much any part of Europe. You should be very, very, very familiar with what the European Union is. Everybody who studies law in Europe will have to have studied the European Union and have to have studied EU law in quite a great amount of detail. Even those who are studying law in the UK, where we no longer are members of the European Union, will have to study EU law as a core and foundational module. So, simply put, we call the European Union, and we can describe the European Union as something known as a supranational political and economic union. This is quite a complicated set of phrases and ideas, but ultimately, what the European Union is an institution, a political and economic institution, which is made up of a number of states within the continent of Europe. And these are known as member states, and we will call them from now on as member states of the European Union. There are currently 27 member states within the European Union at the time of recording this lesson. I'm going to quickly cite this as the 5th of October 2023 as the date in which this lesson was made. So if there are more or less in a few years' time, that's the reason why I've written 27 here, because it's recorded on that particular day. Now, the European Union is often considered by a number of different scholars, academics, and even legal practitioners as a sui generis legal and political entity, which is just a fancy way of saying a unique political entity. It is a unique political and legal entity. This is not to suggest that there are not others that exist. There are not other regional institutions that exist that have attempted in some ways to mimic the structure, the legal powers and economic regulation of the European Union. Two that I can think of here is the African Union, to an extent, has been building this kind of economic and political union within the continent of Africa. And to a lesser extent, you can talk about ASEAN, the sort of association of Southeast Asian nations, which has some of the similar competences in terms of their regulation that the European Union has, and so ASEAN has again is to a lesser extent than other elements of regional institutions, but is a useful example as well. But it is just the case that the European Union, owing to the history of the European Union, the history of how it begins to develop, as well as actually the history of Europe as a whole, it makes it relatively unique. And it gives it a relative uniqueness in terms of the way in which not only the European Union operates within Europe itself, but how the European Union operates on the world stage. Now, we're not going to do any lessons in this series on something known as EU external relations law, which is the sort of way in which the European Union interacts with other states as a unified political and legal entity, and sort of exists within international law. That's a separate series of lessons for the European Law Academy in and of itself. But you should just know that when the European Union, when we talk about the European Union, we do talk about it for a lot of cases as a single unified entity, and there is this sort of commonality that exists, whereby, for example, in the case of international trade, there isn't this international trade with specific member states of the European Union. More so, it is the case that you trade with the European Union as a unified political entity, rather than as with the single member states of the European Union. In terms of the law of the EU, we've seen that since the 1950s, at the end of the Second World War, where we see the development of the sort of early genesis of the European Union, it begins we begin to see a gradual development of EU law. So EU law is not something that comes into fruition as it is now, right at the beginning of the development of the European Union in the 1950s. Instead, it has developed gradually, just like the European Union more holistically. The development of EU law has been made through amendments to treaties, through the entering of new treaties into the broader corpus of EU treaty law, as well as the addition of new member states towards the European Union, and the conferring of what we call competences to the European Union. So competences can be described as the kind of areas of law that are then taken out of the remit of the member states and are given to the remit of the European Union at the supranational level. So one example of this could be, for example, citizenship rights within the European Union. That is something that is regulated not necessarily by member states per se, but rather by the European Union as a harmonized supranational political entity itself. And these are the kind of competences that begin to transfer from member states up to this supranational institution. We'll get to the ways in which harmonization works and the ways in which you have different methods of harmonization, including things such as mutual recognition, when we talk about the single market in a brief amount of detail in future lessons' time. In terms of member states, the European Union actually began as the European Community, the EC, with just 6 member states. And between 1973 and 2013, we would see the addition of a further 22 member states joining the European Union, and this would happen at various different stages and periods of enlargement. So you'd have, for example, the United Kingdom in the 1970s joining the European Union, followed by other member states. We'd see, following the end of the collapse of the Soviet Union and the end of the Cold War, we see quite a significant increase in enlargement when we see a number of Eastern European states, which were formerly members of the Soviet bloc, the USSR, become members of the European Union. And in 2013, we get these sort of 28 member states, which represented the peak of membership of the European Union. We've seen a reduction in the number of member states of the European Union by 1. In 2020, when the only ever member to leave the European Union was the United Kingdom, with obviously Brexit. Now, we'll talk about Brexit very briefly in this sort of introductory series of lessons, but I kind of want to talk about Brexit in and of itself as a separate series of videos, maybe a sort of short little mini series on the way in which Brexit operates from both a United Kingdom's legal system perspective and from the perspective of the law of the European Union. But ultimately, that's obviously the most controversial political thing that has happened to the European Union in recent years. We also have new members that are in various stages of the process, which is the joining of the European Union. So, for example, for many years, Turkey has been a potential candidate member of the European Union. So too as North Macedonia. So too as Ukraine, and as well as Kosovo. And also Georgia. There are others as well, so Bosnia and Herzegovina, and there are probably some more smaller, minor states that want to also join in the European Union as well. And we are probably likely going to see a number of these states join the European Union in the future. Of course, there are some states that are currently, at the time of recording, wrapped up in various different international armed conflicts, like, for example, Ukraine. And there is a lot of political controversy around the idea of Turkey joining the European Union owing to the political system within Turkey. But it is likely that we are probably going to see these number of these member states listed here, or at least number of these states listed here, become member states towards the European Union. So what is this series actually going to entail? Well, we're going to take essentially a general look at the law of the European Union. We're going to be covering the content which would be expected of a typical undergraduate module on EU law. So we're going to be talking about things like the institutions of the European Union, the way in which EU law applies in member states, the idea of judicial review, things like direct effect, etc., etc., etc. And it means as well that we're going to be talking about a number of topics which we'll be exploring in a modest amount of detail, but not necessarily in the amount of detail that we will get to in future lessons. So a notable example of this is towards the end of this series of lessons, we're going to do a good 10 or so videos on the single market and the law of the single market. But for the most part, that is going to be a more advanced series of lessons in and of itself that's going to come out in a separate few lessons in a separate series. So as a result of which, we're going to be covering it to an undergraduate-esque level, but then we will be talking about it in far more detail as a separate series of lessons in and of itself, more advanced series. So just bear in mind that if you feel that we haven't gone into a particular topic in enough detail, it is very, very likely that we will go into it in more detail in the future. So the first major topic is going to be the introduction to EU law. So we're going to talk about what the European Union is. We'll take a brief history of the European Union. We'll talk about the development of the EU. We'll talk about the various stages of development. We might dive a little bit into some of the different theories of European integration. And then we'll talk about the impact of Brexit and the way in which Brexit has not only impacted the United Kingdom, but has also impacted the European Union. We will then get into the sort of institutional law of the European Union. So we'll talk about the various institutions of the EU, including the Parliament, the two councils, the Commission, the European Court of Justice, as well as some other minor institutions. So things like the auditing institutions and some of the minor judicial institutions of the European Union. As well as this, we will talk about the law of the European Union as well. We'll talk about the lawmaking process and the types of law that exists within the European Union. So things like the sources of law within the EU, the lawmaking process, the distinction between the treaties, which is seen as primary law, and the sort of secondary law, which exists as sort of regulations, directives, and decisions. We will then get on to looking at how the European Union law is applied within the domestic jurisdictions of member states. This involves talking about the principle of supremacy, the doctrine of sincere cooperation, and then the procedural mechanisms in more detail. The principle of direct effect, the principle of indirect effect, the principle of incidental effect, and the idea of state liability. We will then finish looking at the law in its general form by talking about preliminary references, the procedure for preliminary references, getting familiar with Article 267, as well as exceptions to this particular procedure, before taking an outline examination of the European Union's single market. This involves looking at the rationales and the fundamental theories of the single market, and then turning to the free movement of goods, free movement of persons, freedom of establishment, and the freedom to provide services. Welcome back, everybody, to Law of the European Union. In this lesson, what we're going to do is talk about the history of the European Union in something of a brief and overview-like fashion, because, of course, the history of the European Union could be, and probably will be, a series of lessons in and of itself in the future. So we're going to take a brief overview at the key stages of European integration, European development, European enlargement, in terms of further members of the European Union being added, and then you could argue a contraction of the European Union with the removal of one of its member states, that being, of course, the United Kingdom in Brexit. So, like I said, we're going to talk in more detail about the historical development of the Union itself, the ways in which it developed from a small collection of states that regulated a small variety of industrial outputs to the massive supranational institution that exists to this day, with very complex and integrated legal systems and complicated methods and modes and competences. So in terms of the early history and its origins, the ideas of European integration are nothing new. They didn't come out of the 20th century, they actually came out of the 18th and the 17th and the 16th centuries, the idea of linking countries in the European sphere together. However, when we talk about the creation of the European Union specifically, and the ideas of integration be gaining more and more prominence and traction, we have to think about the end of the Second World War. The Second World War, of course, being the last great war that takes place in Europe between the vast majority, if not all, of the European states. Now we have new wars that are taking place in Europe. In fact, there is one war particularly that's taking place right now in Europe at the time of recording. Of course, this is the Russian invasion of Ukraine. But in terms of European-wide conflict that has taken place, nothing was quite like the Second World War, and hasn't been since the Second World War. And so post the Second World War, post the sheer destruction that was the Second World War, and post the sheer atrocities that took place in the Second World War, things notably like the Holocaust, there is this growth in ideas relating to not only European integration, but internationalism more generally. It's obviously where we see the establishment of the United Nations, we see the establishment of major international human rights treaties, we see the establishment of things like the Nuremberg trials and the Tokyo IMT as well, and all these different kinds of developments in terms of the prosecution of international crimes. All of these things start to explode. In fact, if you are a student of international law, or if you follow the International Law Academy as part of our collection of channels, you will know that a lot of international law that exists to this day comes out of and post the Second World War. So, of course, internationalism is a very big thing, and so too is the idea of European integration. Not only was there a belief that a war like World War II should never happen again, which is a belief which, I mean, at least I hold, and many other people do still hold to this day, but there was also the growing trend towards international organizations being formed. So we have things like the Bretton Woods organizations, which were the World Bank, the International Monetary Fund. You had the failed International Trade Organization and the Havana Charter, but that was sort of superseded by the General Agreement on Tariffs and Trade, which would eventually turn into, in the 90s, the World Trade Organization. So you could almost suggest that the World Trade Organization is almost an ancestor of the Bretton Woods organizations. But then you also have things like the United Nations as well. Couple this with the fact that post-World War II there is a major wave of decolonization. This takes place across all European empires. The British Empire contracts, the French Empire contracts and loses grip on its territories. That's why we get things like the Vietnam War, for example, and all the other empires that existed in the Americas, in Asia, as well as Africa, starts to contract, and we start to see the collapse of these major world empires. You have a situation where there was a seeming need for European states to, rather than looking outward towards their Commonwealth, towards their colonies, like the Britain and France, for example, they need to look inwards towards the internal domestic affairs of their own state, as well as the internal affairs of their own continent, i.e. European states. And all of these things coupled together to create a situation where we are seemingly looking for European states to examine ways in which they can better integrate with other European states. Some of these commitments to create European institutions takes place as early as the Moscow Conference of 1943, so before the end of the Second World War itself. And indeed the Yalta Conference of 1944. So in those conferences, for example, there was an agreement among the great powers to establish something known as the European Advisory Committee. But it isn't until the Treaty of Rome in 1958 that we see the major movement towards European integration. The Treaty of Rome was the first major establishment of what would eventually become known as the European Union. And it establishes something known as a European Economic Community, the EEC. And the EEC would be signed by the following states: Belgium, France, Italy, Luxembourg, the Netherlands, West Germany. Okay, these are the original founding members, the founding fathers, if you will, of the European Union, as they were the original parties to the Treaty of Rome. West Germany, of course, because Germany at this stage was divided into two, owing to the end of the Second World War and the Potsdam Agreement to divide Germany up into the various different states in which it became, and the different zones or spheres of influence. The Treaty of Rome would also establish a customs union between these member states. Now, for those of you who haven't ever studied international trade law or the World Trade Organization or anything like that, essentially a customs union is a set of preferential trade arrangements that exists in a union of states that are between, whereby the union itself controls the external agreements with other states. So there is a lower, more preferential trade barrier system inside the union of the customs union than there is outside of it. That's essentially what a customs union is. Of course, there are much more legally technical, legally savvy definitions of customs unions as defined in the General Agreements on Tariffs and Trade, but we are not going to talk about that in this series of lessons. The general idea here was that if we were to see the major countries of Europe interlinking major elements of their economies, then there is less chance for these countries to feel the need to go to war. Because if, for example, their coal, steel, iron industries are all linked together and controlled supranationally by an institution like the European Economic Community, then it is more difficult for them to go to war with each other, given the fact that they could just as easily go about negotiations for trade instead. In and around the same time, we also see the integration of energy unions. Now, Euratom and the sort of European Atomic Energy Union, or whatever it's called, specifically Euratom itself, is one of the most overlooked areas of European law, because for the most part it is sort of just sitting in the background in terms of the regulation that it does, because it obviously only specifically regulates a very niche element of energy union, because in the same time as the Treaty of Rome, member states also signed a pact with the European Atomic Energy Community, Euratom. What's interesting here is Euratom was originally not on the table in terms of membership to the European Union and the Brexit negotiations, and then it became part of the negotiations to leave Euratom as well as the European Union, despite the fact that they are technically different elements or different institutions to an extent. Ultimately, what Euratom was supposed to do, the purpose of Euratom is to create a cooperative community in the creation of this new nuclear technology. Don't forget, 1958 we're talking. And so, therefore, we're talking about nuclear and atomic energy. We will get to studying Euratom when we talk about European nuclear law or European energy law in more detail in future lessons' time. So this laid the groundwork. So far we have the Treaty of Rome, we have Euratom, we have the original founding member states of the European Union. Now let's think about the methods and processes by which enlargement takes place. Enlargement takes place in the European Union through a number of stages. The first of these major enlargements takes place in 1973. We see the introduction of new states such as Denmark, Ireland, and the United Kingdom. And then at the same time, there was the possibility that Norway could join the European Economic Community, but then this was put to a referendum vote in Norway and was rejected. Norway is still still not a member of the European Union. Greece would join the European Economic Community in 1981, and in 1985 there was something known as the Schengen Agreement. The Schengen Agreement is a major breakthrough in terms of the integration of European economies, namely the free movement of peoples. The purpose of the Schengen Agreement was to establish a zone within the European Economic Community where there would be complete frictionless travel among member states. It means that if you were in the Schengen zone, you would be able to travel between member states without there being border checks or passport controls. This, the aim of which was to ensure the complete free movement of peoples, as therefore being able to essentially solidify one of the major principles of the Europeans' economic constitution and establish part of the single market, which is what we'll get to in future lessons' time, don't you worry. Between 1993 and 2009, we have the sort of Maastricht to Lisbon treaties. So the Maastricht Treaty in 1992 formally establishes what is known today as the European Union. So it changes the name to the European Union. It was entered into force in November 1993, and the general idea behind the future of the Union was to, firstly, expand into new competences, so to expand into new regulatory competences, and then also to expand into new territories. Specifically, the plan was to enable further enlargement of the Union to include Cyprus and Malta, but then there was a whole host of newly established post-Soviet states, because in post-1993, well, post-1989 to 1991, there was the establishment of multiple different of post-Soviet states. You had Poland, you had Latvia, Lithuania, you had Romania, you had Ukraine, which is still in the process of joining, and you obviously had the Russian Federation as well. So all of these new states in Eastern Europe became open ground and open territory for potential enlargement to the European Union. The new wave of members would join in and around the time of the Treaty of Lisbon, 2008-2009. You see Bulgaria and Romania join in 2007, Cyprus and Malta would join in 2008, Slovakia would join in 2009, Estonia in 2011, Latvia in 2014, Lithuania in 2015. The Treaty of Lisbon would be agreed upon in 2007, and that would enter into force in 2009. One of the major things that the Treaty of Lisbon did was do a number of structural reforms to the Union. It, for example, merged the system of the European Union's three pillars. It also created the position of the President of the European Council and allowed for the establishment of a single union with legal personality. So it made a number of legal and structural and constitutional changes to the European Union. Finally, then, we're coming up to near about the present day, and we have the constriction of the concept of the European Union with the idea of Brexit. Following a referendum result which took place in June, I believe, or July of 2016, from what I can recall, I'm surprised it isn't etched into my memory as a traumatic period of my life, the UK ultimately votes to leave the European Union. And what followed was a complex series of negotiations and processes which would ultimately lead to a formal withdrawal from the Union in 2020, in January 2020. What happened then was that there would be an entering into the transition process. The transition process essentially allowed the UK to remain part of the single market, while a formal and more substantial trade agreement was established, which was negotiated until the 31st of December 2020. The previous lesson, examined the historical development of the European Union and spent a lot of its time talking about, essentially, the growth of the European Union, how member states began to form part of the European Union, became and ascended to the European Union itself. And the process of ascension is something that's really important. At the time of recording, on the 12th of November 2023, recently the European Commission and the European Council released information about potential new members of the European Union, including states like Ukraine and Turkey, for example. So let's think about the process of accession to the European Union in more detail. How does one, as a member state, or as a state, should I say, wishing to become a member state of the European Union, go about this process? How does this actually happen? And like I said, we've briefly examined the history of the European Union, specifically points of enlargement and the process that this takes. And so we're going to talk about this in more detail, looking at how the European Union actually adds new members, the requirements, the criteria for adding new members to the European Union, as well as the current candidate states that could be new members of the European Union in the next few years. So EU accession refers essentially to the formal process by which a state will join the European Union and become a member state of the European Union. Very, very simple. Now, the process of accession itself involves essentially the joining of the original founding treaties of the European Union as amended by subsequent treaty agreements. And so this is what the process of joining actually entails. So in terms of the technicalities of joining the European Union, the process itself involves joining the founding treaties, signing on to and becoming parties to the founding treaties. The requirements of a state to become a member of the European Union, however, are outlined in something known as the Copenhagen criteria. So the negotiation process by which a member will become a member state, join the European Union, therefore, and as such, joining the original founding treaties, is known as the Copenhagen criteria. These were set out in 1993, prior to the more rapid enlargement of the Union, with the accession of states like Malta and all of the Eastern European states like Latvia, Lithuania, and Romania. And they essentially involved the following requirements for a member state to become a member of the European Union. They must be a, quote, European country. Now, what this is actually entails, what it means to be a European country, is something that's quite interesting, given that the clear borders of what Europe is quite interesting to talk about. Turkey, of course, is a member of Europe, given the fact that you sort of have Istanbul being the edge of Europe itself. But then what about countries such as Georgia? Or countries such as Kazakhstan or Azerbaijan. And as we go further into places like the Middle East, how far do we go south, shall we say, before we can say, okay, we're no longer in Europe, we're now in the Middle East, or we're no longer in Europe, we're now in Africa? That's an interesting question. But in terms of the candidate countries that are currently on the list, they are unequivocally European countries. Okay, so countries like Turkey, countries like Ukraine, or countries like Georgia are all countries that are in the process of potentially joining the European Union, and they're all countries which are actually European countries. The further they enlarge, the more this question will become more and more interesting and more controversial, essentially. The second criteria is that they must be a democracy. Okay, so they have to exist in what is required to be a democracy, a democratic state. They cannot be a theocracy, they cannot be a dictatorship or a totalitarian state in any way. They must have free and fair elections. Okay. Next, they must have a functioning market economy. Now, you might think that this is just the imposition of capitalist ideology onto these ideas of European Union, but it makes sense that a functioning market economy is a requirement, given just how much of an economic constitution the European Union has. Joining the single market requires you to have a functioning market economy. You couldn't have a command economy in the single market because it wouldn't exactly integrate particularly well. There must also be the respect of the rule of law and fundamental human rights. Again, very simple and easy to understand. And then there has to be the final element, okay? This is sometimes known as the aqueous communitaire, and this is the idea that they must be willing to access and implement EU law. So there has to be the ability and the willingness on the part of the member states to actually apply EU law in their domestic context. That is arguably the most important element of this particular process, because every single candidate member state is going to have either achieved or be on the way to achieving the other four requirements. They're going to have been a European country, they're going to either be a democracy or on the way to the democratization of their state, they're going to be on their way to functioning market economy, and they're going to be on their way to respecting the rule of law and human rights. So then the question therefore is, are they willing and able to access and implement EU law? Aqueous itself, the law itself, aqueous. The Copenhagen criteria essentially means that there is no dictatorship, no state-run economic system, or any kind of states with with poor track records on human rights joining the European Union. Even if the Copenhagen criteria are met, however, it is not necessarily a guarantee of a position as a member state, because they still have to go through the accession process. Before the normal negotiation process will take place, the member state will have to meet the Copenhagen criteria. And then once this happens, and after usually a period of time doing a number of informal negotiations with members of the European Union, the European Council will have a unanimous vote to begin the formal negotiation process. Okay, this process of negotiations centers around the final of the Copenhagen criteria, the ability for the potential member state to adhere to the community law, to adhere to the aqueous communitaire. The community law is divided into 35 separate policy chapters, each of which are going to be extensively negotiated to ensure that compliance is possible with the complicated and detailed process of EU law itself. And then once this happens, And once it is ensured that they are able to comply with and negotiate and apply the 35 separate policy chapters of the community law, the formal acquisition treaty will be drawn up. So let's think about some of the potential candidates. So two of the most prominent candidates currently include Turkey and Ukraine. Ukraine almost had the speeding up of processes following the invasion of the Russian Federation. There's been a lot of political back and forth relating to Ukraine's membership of the European Union, with states like Russia flaring their nose up at the idea of European membership. Countries like Turkey have also got controversies with them. So there is also the controversy of Turkish human rights track record, whether or not they actually adhere to the Copenhagen criteria. But these are the two biggest, most prominent potential candidates. Turkey being a little bit, Ukraine being further along the process of membership joining than Turkey. Of course, there are various issues with both, as I've just mentioned. You have the controversial track record in Turkey, as well as respect for the rule of law, and you also have the current embroiling of Ukraine in an international armed conflict with the Russian Federation. In this lesson, I want to talk very briefly about the concept of Brexit in relation to the European Union. This is more going to be a lesson talking about specifically Article 50 of the European Union, and it follows on from the previous lesson where we talked about how new members are acquired in the European Union, i.e. the accession process. This is going to be an examination of the process of leaving the European Union. Now, the concept of Brexit and the European Union, it probably merits its own separate series of lessons, and potentially we will be doing that in the future, covering the concept of Brexit and the European Union and the entire legal, political and historical process that took place. So we're going to be quite brief in our understanding of specifically talking about Brexit itself and focusing a little bit more on the concept of leaving the European Union. So like I said, the previous lesson spoke about the process of member states being able to join the European Union, the accession process, and this lesson is going to talk about the process of leaving the European Union. Now, the reason why this is specifically a lesson that is titled Brexit and the European Union is because so far, at the time of recording on the 13th of November 2023, there has only ever been one member state to leave the European Union. This is, of course, the United Kingdom. And it seems to be the case that, for the most part, the United Kingdom might be the only member state to leave the European Union, given how catastrophically bad it went in both terms of the resultant deal that was had, the general mediocrity of the state of the United Kingdom post-Brexit, and also the problem of actually achieving Brexit in the first place, going through 3 prime ministers to do so. All seems to suggest that leaving the European Union is not something that many member states really feel like they want to do at this stage. There is, of course, a lot of different kind of Brexit-related leaving European Union kind of fervour and rhetoric around some member states. But for the most part, I don't think that there is a significant and substantial movement in any of the other member states to leave the European Union at the time of recording. So, the term Brexit is a term that is coined to describe the British exit from the European Union. I'm pretty sure it was either Channel 4 or I want to say Channel 4 that first came up with the term Brexit, and they probably should have trademarked that because the amount it's become essentially synonymous with the idea of the Great Britain leaving the European Union. And it formally takes place on the 31st of January 2020, despite the fact that the referendum, which was held to essentially decide whether or not the United Kingdom should leave the European Union, was held in June 2016. And so you can probably see from that the kind of process that was had that took 4 years, essentially, to go from the referendum itself, which was, of course, not legally binding, all the way to the legally binding withdrawal from the European Union on the 31st of January 2020. At this point, the start of 2020, the United Kingdom entered into a single-year transition period. What the transition period essentially was the UK was no longer officially a member of the European Union. That was established, and that was easy to understand. But the UK still remained part of the European Union's economic system, so it still remained part of the single market, and they did so until a formal trade agreement was made that could be a lot more established. And so that's a result of the fact that we have a transition period over the year of 2020. Which, given what happens in 2020 and the creation of and the wave of pandemic that takes place, it's probably a good idea that we remained part of the single market for that year. So while this lesson is going to be brief in terms of the overview of the Brexit process and the process of leaving the European Union, it should be noted that the study of Brexit is a series of lessons in and of itself, like I mentioned, and I feel like I want to do a series on the study of Brexit, looking at not only the legal implications of leaving the European Union, but also looking at some of the political and sociological implications that were had in terms of leaving the European Union. It's a very fascinating process that took place in 2016. So the withdrawal process wasn't actually present within the various treaties on the European Union until the Treaty of Lisbon. So it was amended, essentially. The Treaty on European Union was amended to include an extra additional provision, this being Article 50. Article 50, which was drafted by Lord Kerr, was the provision which allows for a member state. It was the mechanism which essentially allows for a member state to leave the European Union. While relatively brief, of course, Article 50 has very important implications. I'm just going to read to you Article 50 in its entirety. Article 50, Part 1 says that any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. A member state which decided to withdraw shall notify the European Council of its intention. In the light of the guidelines provided by the European Council, the Union shall negotiate and conclude an agreement with that state, setting out the arrangements for its withdrawal, taking account of the framework for its future relationship with the Union. That agreement shall be negotiated in accordance with Article 218, Part 3 of the Treaty on the Functioning of the European Union. It shall be concluded on behalf of the Union by the Council, acting by qualified majority, after obtaining the consent of the European Parliament. So Part 2 of Article 50 essentially talks about the process of negotiation with the member state that is wishing to leave on the idea of a future relationship that the European Union would have with this member state. The idea here is that leaving with some kind of concluding agreement post-Brexit or post-leaving the European Union is a desirable outcome. And for those of you who lived and was politically active through the period of Brexit, through sort of 2017, 18, 19 and 20, you will be familiar with this idea of, and this concept of leaving without a deal, leaving the European Union without having any kind of negotiated agreement with the European Union, any kind of negotiated preferential agreement with the European Union. And this is sometimes known as WTO arrangements, which essentially refers to the idea that rather than having our own separate trade agreement that is defined between the EU and the UK, we would essentially go to the general rules and principles which are established by the World Trade Organization agreements. That is the idea that was had here, and this is what Part 2 essentially tries to combat, to try and actually get some kind of an agreement. Part 3 talks about the process in which leaving actually takes place, and it says that the treaties shall cease to apply to the state in question from the date of entry into force of the withdrawal agreement, or failing that after 2 years of the negotiation referred to in paragraph 2, unless the European Council, in agreement with the member state concerned, unanimously decides to extend this period. For the purposes of paragraph 2 and 3, the member of the European Council or the council representing the withdrawing member state shall not participate in the discussions of the European Council or council in decisions concerning it. And then finally, if a state which has withdrawn from the Union asks to rejoin, its request will be subject to the procedure referred to in Article 49. So these last 3 provisions are quite interesting. Part 3 is very, very important. Because what Part 3 tells us is, assuming that you can have a negotiated agreement with the European Union as per Article 52, as we see here, Article 50 Part 2, should I say, then at that point the treaties will no longer apply to that state in question. Failing that option here, you have 2 years essentially to come up with an agreement, at which point the treaties will cease to apply regardless. This is something which is subject to a number of different conditions. So the 2-year limitation, of course, can be extended if you feel and the European Union feels that there could be an agreement reached, and so therefore there is a unanimous decision to extend said agreement. Or you could essentially withdraw your concerns notification to Article 50 and essentially quash the whole thing in and of itself. Part 5 is also quite interesting in the sense that it allows for a mechanism by which the member state which has left the European Union can potentially rejoin the European Union in the future. So the door is open to even the United Kingdom rejoining the European Union in the future. And given the fact that, given the general outlook towards membership towards the European Union, and given the general outlook of non-membership being not particularly very pleasant in terms of the kind of things that were established, it makes sense to suggest that the UK may join or rejoin the European Union in the future. You might think that I'm being generally political in my outlook towards Brexit, but I think it is objectively the case that Brexit was a bad idea and continues to be a bad idea. This isn't even a political opinion anymore. This is just objective reality. Moving on then, let's talk about the transition period. So the transition period specifies that once the formal withdrawal from the European Union takes place, there remains largely the same regulation for the rest of the year. So nothing really changes in terms of how goods and services are regulated or the free movement of people, etc., etc., for a year during this transition period. The only thing that is different is the fact that you no longer have any kind of political representation in lawmaking within the European Union. Since the UK formally left the Union on the 31st of January 2020, there was a transition period until the 31st of December 2020. The formal post-Brexit EU-UK Trade and Cooperation Agreement was finally signed on the 30th of December 2020, so cutting it fine, and was the formal agreement between the UK, the EU, with, in addition to this, the European Energy Community as well, Atomic Energy Community. Now, it is a particularly huge agreement. I had to, as a little side note, earlier on this year, I had to do some research work at the university I work at, and one of the things involved me going through and reading the EU-UK Trade and Cooperation Agreement, which was a arduous and slow 2,000-page read, and not something I would recommend people do in their spare time. But for now, let's just leave this idea of Brexit on the table, and we'll start to talk about some of the more structural components of the European Union in future lessons' time, focusing on ideas like EU institutions, lawmaking, and the process of legislation within the European Union.